Today, a federal judge dismissed the charges against a Kansas man who had a machine gun. The judge essentially said that the ban on machine guns is unconstitutional, saying prosecutors failed to clearly establish constitutional grounds for the ban.
And you know the anti-gun crowd, their butts are puckered up right now. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification, multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like channel, like content, what I do here, you can support me with the link. Everything's appreciated. And once again, if your comments disappear, I'm not doing it. If I remove your comment, I'm going to tell you I did it and why I did it. There's a growing problem with this platform. Comments for specific channels and content being removed with no notice. So if it disappears, I'm not doing it. Let's talk about this. And this is massive news. And as always, I always hesitate a little bit. I don't jump all over it until I got some more information. But Kansas judge, federal judge, has ruled that machine guns are covered as bearable arms under the Second Amendment. And this, of course, is creating a firestorm across the country because obviously this has massive implications. And the background to this story is there's a man named Tomari Morgan who was arrested for being in possession of two firearms that were modified to fire fully automatic. This was last year. His lawyers have now argued that the possession of these two items was covered under the Second Amendment, which of course the state said no, they are not. So they basically went to the next level. And this judge out here in Kansas, and this is John W. Brooms. They made a big point of saying that he was a Trump appointee, obviously for political reasons, but he stated that these items are covered under the Second Amendment as bearable arms and cannot be banned. Thus, his being in possession of them did not make it illegal. Now, I want to make sure I give you as much detailed information as possible, but so I'm going to come right here. But Kansas judge throws out machine gun possession charge, cites Second Amendment. Federal judge in Kansas has tossed out a machine gun possession charge and questioned if bans on the weapons violate the Second Amendment. Now, you're going to hear arguments all over, for no doubt. No doubt. But here's the thing. Bruen states that if it wasn't illegal when the Second Amendment was written, it's not illegal now. You can't arbitrarily make rules and laws that go against the foundational understanding of the Second Amendment. So, we're definitely going to hear from both sides on this, but a federal judge in Kansas has tossed out a machine gun possession charge and questioned if bans on the weapons violated the Second Amendment. If upheld on appeal, the ruling by U.S. District Judge John W. Brooms in Wichita could have a sweeping impact on the regulation of machine guns, including homemade automatic weapons that many police and prosecutors blame for fueling gun violence. Now, that's a bit, that's a play on semantics here, because these people who are using these Glock switches is exactly what they're talking about here to commit crimes on the streets of America. They're not following the law. A lot of these people are under the age of 21. So the guns that they have to start, just having possession of the firearm is illegal. So putting a Glock switch on is nothing. It's nothing because they've already broken the law. So what makes you think that this ruling is going to add to it? It already is happening. And we have all the regulations on the planet. We have more gun control laws now than we did when the Second Amendment was written, and yet violence keeps going up. So I'm not going to buy this argument that all of a sudden this judge's decision on this one case is going to escalate violence. It's bullshit. But Brooms, well, here we go. An appointee of President Donald Trump on Wednesday dismissed two machine gun possession counts against Tomari Morgan, who was indicted last year. Morgan was accused of possessing a model AM-15 300 caliber machine gun, which is Anderson Manufacturing, if I'm not mistaken. So it's probably just an AR that was modified, and a machine gun conversion device known as a Glock switch that can make semi-automatic weapons fire like a machine gun. Quote, the court finds that the Second Amendment applies to the weapons charged because they are bearable arms, which technically is true within the original meaning of the amendment, Brooms wrote. He added that the government has the burden to show that the regulation is consistent with the nation's historical firearm regulation tradition. Now, as of Friday, no appeal has been filed by the U.S. Attorney's Office in Wichita, and they declined comment. Federal prosecutors in the case said in early court filings that the Supreme Court had made that clear, that regulations of machine guns falls outside the Second Amendment. I don't agree with that, though, and of course, here we're going to talk about Bruen, but here we come down to here. Now, these are law professors, and once again, opinions are all opinions are biased. Even when they base it on law, it's still some edge of bias by the person saying it. But Jacob Charles, an associate law professor at Pepperdine University who tracks Second Amendment cases, said the Kansas ruling is direct fallout from the Bruen decision. It gives lower court judges the ability to pick and choose the historical record in any way that they think the Second Amendment should be read, Charles said. Charles expects Bruen's ruling to be overturned, citing Supreme Court precedent allowing for the regulation of machine guns. Eric Rubin, a fellow at the Brennan Center and associate law professor of Southern Methodist University, agreed. Quote, as far as I know, this is the first time in American history that a machine gun ban has been found unconstitutional in its application, Rubin said. Now here comes the gaslighting. Sher Feldman of Brady United Against Gun Violence called the ruling an incredibly dangerous decision, and it's inconsistent with what the Supreme Court has said the Second Amendment means. Okay. And then there's another quote from Everytown for Gun Safety, but Everytown Law, a gun safety group, said laws banning machine guns are crucial to public safety and called them weapons of war. Yet we have machine gun bans, yet we have this massive problem in liberal-run Democrat inner cities of people using these illegal firearms because they're illegal, because they're underage to start with. They did not buy these firearms legally and then modifying them to shoot fully automatic. That problem is rampant. Yet this decision is going to make it worse. Quote, it's appalling that the district court would so brazenly put the deadly agenda of the gun lobby over the safety of Kansans. We are shocked and dismayed by this decision, said Janet Carter, Senior Director of the Issues and Appeals at Everytown Law, said in a statement. Any gun control initiative that gets shot down by the court, they're going to use the same language, which they have done repeatedly. Shocked and dismayed. Not buying into that crap, but I'm going to come out here. So there it is. Now, I want to give you this piece of video. This is supposed to be a legal expert, and he says something very interesting. I'm going to go ahead and give you that.
It's the first time a court has ruled this way since after a 2022 landmark decision from the Supreme Court. So to break this down, we have our chief legal analyst, Khalif Rhodes, with us. So in that 2022 Supreme Court ruling, the High Court said, quote, that restrictions need to be consistent with this nation's historical tradition of firearm regulation. What does that mean?
You're talking about the Bruen decision, and this has a wide-reaching implications, but it means, do we have a history of wanting to ban this type of activity? Do we have a history of banning folks that are domestic violence, folks? Do we have a history of banning people that are convicted felons? Do we have a history, or in this case, of banning just machine guns? And so Justice Thomas doubled down on it, which is now saying that we have to have a history before you can ban something when you're talking about firearms. And if there is no history, and it really hasn't talked about the history. Does the history need to be 50 years, 60 years, 70 years, 80 years, or does it need to be recent history? They haven't elaborated. But what it has done is cut out this new carve out for folks to say, well, some of the things that you're attempting to do that maybe we've done for the last 40 or 50 years aren't constitutional. There are a couple of concerns that I have with this judge's opinion, specifically that I think there's a misstep in terms of the way he's approaching how and who implements the laws. Congress, for sure, they are the legislators. They write our laws. And so when you're talking about whether something is constitutional, they have constitutional authority to write the laws. Now, back when it was prohibition, they were attempting to, talk about who could get access to machine guns. And then in the 1860s, they did a complete ban on machine guns. But this wasn't an agency like the most recent cases where you talk about bump stops, where it was, agencies like the ATF doing these advisory opinions and these rulemaking authorities. And then the courts have said, you know what, you don't have authority to do that. This was actually done by Congress, which constitutionally they're allowed to do. So his argument to say that it's unconstitutional, I think, is problematic. The second portion is typically you wouldn't have a trial court judge making that determination. Normally what you'd have is a person be convicted, then they would appeal, and then on appeal, either on the federal appeal level or the Supreme Court would address it. And they say, hey, is this even constitutional? So I think this one obviously will be appealed. The state hasn't made a determination yet, but it seems like that judge in this moment has to follow what the Constitution or what our Congress has put it as law. And so for me, there are a couple missteps with this comment.
Heard that. Now, with the Supreme Court makeup as it is now, how would this play out if it does go before the court? Are they going to stick with what they claim is set precedents? Or are they going to fall back on Bruen and say, machine guns are bearable arms? I did a video on the military picking up a new standard. They're changing out the M4 for the XM7 and the SAW or the M249 for another, basically based on the same principles, but another firearm. And the argument that was being put forward was, seeing that the military is getting these are what you can consider common use. And these items should be available to the public. Now, in some shape or fashion, I think these firearms that the military is picking up are going to be available to civilians, but not so much the machine gun version. But then again, this opens up that door for this to happen. I have no skin in the game as far as this goes, but what it will do, it will unlock the monopoly that the machine gun owners have. Because even if you don't know this, machine guns are incredibly expensive because they have to be made before a certain day, 1986, which makes anything pre-1986 incredibly expensive to own. If the Supreme Court says that machine guns cannot be banned as they are bearable arms, it will end that financial monopoly that they have, because then machine gun prices will plummet. Not saying that the process to get one will change, but it will definitely drive the prices down and make them affordable. This whole notion that this case and this ruling is somehow going to change the face of crime and violence is absolutely idiotic. We have a machine gun ban, and yet this violence, which is relatively new when it comes to these Glock switches, is out of control. I don't see how this judge's decision is going to change what is happening when it comes to crime and criminal activity. But once again, another case we have to keep an eye on, because it is setting foundational work. And once again, I am personally, with skin in the game, I am personally waiting for an assault weapons ban case to make its way to the Supreme Court. I'm hoping that Grant versus Lamont gets there soon, because I suspect that if an assault weapons ban, I'm speaking to Connecticut people, but if an assault weapons ban case makes it to the Supreme Court and it's not Connecticut's, and the Supreme Court overturns it, I suspect that Lamont and his cronies are going to do something very quickly to once again undermine the Supreme Court's ruling on a ban. That's just my thoughts. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'm going to see you on the next one. Peace.